Hi, my name is Charles Hadad, and this is my colleague, attorney Mallory Sikora, and we're with the firm, the Lynch Law Group. We both practice in our estates and trust group, and we're here to talk to you about another important topic today called probate.
So I guess first off, what is probate?
So probate's a process, it's a legal process where if you pass away and you own an asset up to a certain value, that you legally have to go through in order to authenticate and appropriately clear and transfer assets from a legal standpoint from that decedent to the beneficiary or heir. Pennsylvania has a legal process that has numerous steps that you have to follow depending on the county that you resided upon your death, and your executor or personal representative is appointed and has a duty to pass through that process in order to transition that estate.
So how will our client know if they need to probate?
That's a very, very good question. I definitely recommend that you seek counsel to determine properly whether or not you have to probate. Some states do not require probate. In Pennsylvania, there's statutorily two thresholds that are triggered in order to minimize the requirements of probate. For instance, if you own an asset when you pass that's $10,000 or less, or if it's life insurance, $11,000 or less, under Section 3101 of Title 20 of Pennsylvania's Purden Code, you can actually transfer those assets to next of kin by affidavit. And that's really important to note because on nominal assets, probate's not required. If the asset exceeds $10,000 but is below $50,000 under 3102 of that same Title 20 of Purdens in Pennsylvania law, your next of kin or loved one can do what's called file a petition for small estate and request that the court issue an order authorizing the transfer of that asset, but again, still sidestepping the probate process. If your assets that you individually own with no beneficiary when you pass away exceed $50,000 of value, in Pennsylvania, that would trigger probate. Probably the most common example is if I own real estate in my own name. That is going to trigger probate, and your executor has to be sworn in, and then there are statutory requirements and duties such as advertisement, inventory, creditor notices, beneficiary notices that have to be complied with until that executor can receive discharge to complete the probate.
You mentioned counsel. Should you have an attorney handle this for you, or can you do it by yourself?
So a lot of people think I can just handle DIY, do it yourself. Probate, I would stress and recommend that you have counsel, and I will tell you some counties require entry of appearance of counsel in order to properly comply with their rules. It is always advisable that you have counsel by your side through this process because there are a lot of steps, even though they might seem straightforward and it might seem just like it's paperwork, there are a lot of legal steps that have to be followed, and if you misstep as a personal representative, you can be liable from a legal standpoint on that issue. So I definitely recommend that you have counsel by your side to guide you through it, to make it a very smooth administration process in order to get through the probate. If you have any questions related to probate and whether or not it applies, whether or not it can be minimized, and whether or not you need counsel, feel free. Do not hesitate to reach out to myself or Attorney Sikora. You can look us up on our website, which is www.lynchlaw-group.com. We have several offices located in Western Pennsylvania, one in Southpointe and one in Cranberry. We'd be more than happy to schedule a consult with you to answer those questions. And feel free to continue to look for our additional videos and blogs on other great topics. Thank you.